morning. My name is Tanaka. I'm a marine law fellow over at the Division of Aquatic Resources in the State Department of Land and Natural Resources. Today, Mike asked that I kind of give an introduction to the concept of an enforcement chain and how it might be useful to help think about how we might address the entire enforcement infrastructure, not just the officers, like Mike was saying, but the system as a whole, and looking at ways where we might be able to leverage resources or use opportunities that haven't necessarily been used before. So just as a general concept, enforcement chain, I like to think of it as the formal and informal processes and relationships involved in fulfilling law enforcement functions. Processes is meant to be interpreted broadly, so that will include authorities, that will include resources. And these things involve formal and informal. There's processes set by law, relationships that are institutional, and there's also relationships that develop because maybe last year you guys stood shoulder to shoulder multi-agency operation, and now you have working more interpersonal there that facilitate. But before we get into it, just want to touch upon what some of the functions of resources law enforcement have traditionally been considered to be. So just talking to folks and doing some literature research, particularly in the natural resources context, one of the main functions is education, like educating users, the public. We also want to, another function is deter violations, so to basically make it so that the costs and risks of non-compliance outweigh the benefits. I mean, costs and risks of non-compliance outweigh the benefits of violating the law. Rehabilitation, so that idea is related to the internal value system of a violator, and to what extent can you shift those values so that compliance is something that they believe in, as a moral thing, as opposed to just a constant method. Consideration. Restoration of lost value. If somebody takes a resource worth, so many dollars, does law enforcement recover that lost value? And particularly in the context of resource management, when you have open pool resources or like the ocean where anyone can go and fish or explore it, you also want to be able to ensure mutual compliance among the stakeholders. Basically, what that speaks to is the idea of community-based management. To get different stakeholders to sit down and agree to restrict their own activities, they need to be sure that others will also restrict their activities accordingly. And so these are just ideas that we want to keep in the back of our head as we look at the chain, and eventually we'll use them to see how the chain will be improved to better facilitate these functions. So thinking about who's in charge of these things, like it's always people that implement the law, that make laws, and so and it's not one person. It's never, at least in this context, it's not one agency or one person. It's going to be multiple agencies and different individuals, and what are the barriers to fulfilling these functions? So today, I guess to kind of illustrate the concept, I'm going to focus mostly on the state nearshore aquatic resources. So I won't really go into the federal jurisdiction stuff, but there are federal laws that apply in nearshore waters. But yeah, so only the state process. As was mentioned earlier, education is always a consideration when unfortunate. For these reasons, does the public even understand how to comply, and does the public understand why it's important to comply? If you, to the extent you can enhance those, and it mitigates the need to go and do reactive after the fact. And it's a pretty it's a pretty formal and informal process. You have the DLNR, that's Division of Aquatic Resources. So we make the rules and basic policies. We want to make sure that the word gets out to the public, and a lot of times, the people that are in the field actually educating the public are the resource enforcement officers. So make sure that they're informed. We have a lot of help from community groups, NGOs, Makai Watch. In addition to fishing stores, clubs, other communities. But getting more towards the actual citations. So one of the first things you need is to be able to detect violations and to catch people when they're doing police earlier stuff. These functions are supported by the public. There's a hotline. There's Makai watch groups that are coming up trying to see how they can help. Be the eyes and ears or add more resources to DLNR. DLNR is the primary agency that enforces our state resource laws. County police also have the authority to enforce resource laws. So that's the formal part. The formal part is whether the relationship is there, the training is there. So as we go through this, I'm going to point out the different agencies that are involved in each step, so you just kind of get an idea of like the different jurisdictions, different things you need to and there's also and so when you look at detection and prediction, sometimes you want to dig deeper into more specific processes that go on. So one example is the what happens when a citation is issued. So like just you talk to people, you figure out what's the public sees a violation occurring at the beach, and they can call a hotline to go to dispatch. There's a field officer supervisor who pushes out to field officers. You can go out and say they do issue a citation, then he makes a report, or they issue makes a report. It's compiled into the field soup, who then sends it out to the branch. And I think this is, if I'm not mistaken, I think those binders that he's carrying are all of the rules that DLNR has to enforce. So you get an idea of the kind of knowledge expertise that's required. After a citation is issued, arrest is made, there's actually two distinct processes that can take place. There's a criminal side and a civil side. And I'll go into detail. If you look at the criminal side, this is a more traditional process. That's basically right now what we rely on. First thing is the criminal complaint and summons. This involves the judiciary, so state district courts. Also involves the county prosecutors, so whether it's Maui County, Honolulu County, like it's a county agency, they're the ones that actually go to court and prove beyond reasonable doubt that the violation occurred. And DLNR and DLNR, they file a complaint with the courts. You have to act as witnesses or substantiate. After the complaint is filed, then there's usually Raymond. Raymond dates usually actually issued on the ticket that we were given today. And that's an opportunity for violators to make a plea. If he pleads guilty, then it's if the judge accepts that plea, it's up to the judge, the district court judge, to decide what kind of penalty is appropriate. Again, when you think about penalties that come out of this, is the defendant educated? Is he deterred from doing future violations, or has his value system been rehabilitated so that he knows it's a good thing to provide? And is the value resources appropriate? Sometimes the complaint's dismissed at this point. Either prosecution declines to prosecute, or the judge finds a defect in the process. There are some no-shows, in which case a bench warrant is issued, and basically the person has to come back to the court and pay off the bench warrant, and they get a new every day. If the defendant pleads not guilty, then it goes to trial. And if they're under certain income level, then they entitled to a public defender based on the criminal nature of violations in this process. At trial, again, it's county prosecutors, it's the judiciary, the district court judges, and to prove violations of the county, you need witnesses, expert witnesses, such as our biologists, to say this is our OB that is regulated, or things they don't normally in situation between other district court cases. If there is a guilty, so after trial, defense is found not guilty, or it's dismissed or acquitted, or defense found guilty or agrees to the plea agreement, which is something where the defendant and the defendant's attorney, the prosecutor, and the defendant kind of work out a deal where they can plead to maybe lesser offenses in exchange for pleading guilty. assuming a guilty plea or plea agreement, then again, it's conviction disposition. There's also a right to appeal. So if you lose a trial court level, you can file an appeal to a higher court, and at that point it's prosecutors. That's a criminal process, but we also have two civil processes that the department can use to address violations. The one that's folks from Makai may be more familiar with is the what I call a submittal process. This involves the Board of Land Resources, Division of Plot Resources, which prepares a board submittal and knowledgeable assessments to demonstrate what the loss value of resources are. They'll get sometimes they're asked to serve notice on the defendant. They also provide testimony. The reports they draft document violation after this submittal. So again, it's usually the division at this point that crafts the bill and presents it to the board. At that point, the board can find person in violation or not in violation, and impose administrative penalty. That's not all the differences between if the alleged violator wants to appeal, then he's entitled to a case hearing, and this is like a trial. He's entitled to an attorney. They can subpoena folks. It involves, same folks, in addition to the state attorney general, who is now acts sort of like in the prosecutor capacity to present the case. It's similar to the criminal court trial. There's a settlement process. So like a plea agreement, the violator can agree, they'll agree to admit the violation or pay some fine in exchange for the case being drafted. And then again, after the case in court, you can confirm their fine. There's also most recently what's called a civil resource violation system, and basically it allows us to kind of leapfrog this first step where the board actually has to find some violation before a fine can go up. Civil resource violation system, we call it service or CRVS, involves a hearings officer and the division that's relevant to the process of quality services. With service, you need to have a penalty schedule promulgated by rulemaking for Chapter 1. So have one first violation involving some of these things, this much money. And so it's all laid out. And like I said, the service officer can either, after service order is issued, they can uphold the violation and impose a fine. If the person disagrees, then they're again entitled to contested case, which involves and contested case hearings can be appealed to the Circuit Court of Appeals. It's not at this point. It's the Attorney General is not the prosecutors that would be basically defending the DLNR's decision. So just an example of how, once you lay it out, once you kind of see what these processes are, how the system works, then you can kind of look at where there might be gaps, in the links, I guess. So for example, detection and interdiction, like one more, I think, well-known issue that folks have, or concern folks have, is in coverage. Like, are there enough officers that have the presence to deter compliance, educate folks? Deter violations, educate folks, and really such compliance. And so, as I said earlier, it's people that implement these, so you might want to talk to folks that are involved in the process to see maybe where we have to. So one thing that's pretty easy to see, they have 120 officers for the entire state, and very small administrative staff. In comparison, who knows how many people or how many officers the Honolulu Police Department has, just for a walk over. 2,000. They have almost 2,000 officers, 400 civilians. And that's just for one of them. So, maybe that's a place with a little gap. shame. You can also, looking at these dual processes, or actually no, sorry. So criminal process then, as you may have noticed, there's a lot of different agencies involved. So, it's going to be DOCARE that issues a citation. You have the state judiciary, that the district court system, which they do all traffic cases, interposition cases, misdemeanors, all county laws, non-jury civil cases, small claims, a huge list of types of cases up there, and DLNR research laws. In addition, it's also going to involve the county from the prosecuting attorney, which is the Traffic and Misdemeanors Division. At least for this county, it's different for Maui and Diga. And in some cases, if there's going to be, if there's expert testimony needed, if they got to verify that this was a Mujocephalus, instead of a local or something, you got to call an expert witnesses to verify that. So it would require someone else. And as you can see, the three distinct governmental, bodies, and so that requires, that would require a lot of interagency interaction, which you can maybe flesh out when you start talking to these folks. You can also look at the different options you have. So there's as you see, a criminal process and a civil process. Looking at the authorities behind them and what's available. You maybe do a comparison to see how one process might have functions that are desirable or might be useful on the other side. So in criminal court, it's a criminal court, so you're subject to criminal record. Potential penalties in prison up to 1 month. It's a petty misdemeanor, so generally it's a $1,000 maximum fine. It's a $250 minimum fine. Often judges don't read that part of the statute. They can't subject to probation, community service, not injunctive. Comparatively, on the civil side, there's no criminal record, there's no criminal issues there, so it's just right now a monetary fine. But it does allow monetary fines per specimen. It's in addition to a fine per violation. So if someone catches 10 fish unlawfully, then there's potentially subject to 10 times, or to 10 different fines, whereas in the criminal side it might only be one. If someone doesn't show up at a criminal court bench one, as earlier, civil court, you could be fined and found in violation of that section. This is a civil process. Criminal side is multiple agency involvement. There's issues of prioritization. There's the prosecutors. How much weight do the prosecutors and judges put behind our cases if they got to deal with everything else they got to deal with? Whereas in the civil side, it's mostly about the interpretancy. That's within, it's within our area of focus. And criminal side, it's a form of court, so there's strict rules of evidence that apply. And here's the exclusion rules, and you got subpoena witnesses, you got to authenticate, photographs and so forth. On the civil side, it's it's an administrative process, so all of those rules of evidence are relaxed. The burden of proof is also lower on the civil side. It's more likely than not for clear preponderance of evidence, which is like 51%, as opposed to the criminal side, which is beyond reasonable doubt. If you go through the civil process, particularly through the DLNR, those hearings are relatively transparent. The submittals are posted online. Board hearings agendas are up usually a few days before at least. Whereas folks have a lot of difficulty trying to get into the criminal side of things and see what's going on, what happens in other terms and citations. One of the advantages of the criminal side, though, is that it's the side we use. So it's relies on traditional law enforcement processes. They're standardized. The civil process we have, we rarely utilize it, and it's still a relatively decent approach. One thing that came up when I was looking at this is, on the criminal side, there's a relatively what they consider strong post-conviction follow-up. So if someone gets a fine and they don't pay, then there's remedies like putting a stop on the driver's license, things that kind of incentivize them to follow through with what they did to implement and impose on them. Civil side, it's it's not, we can't put anyone in jail with that. We're not tied to transportation. what we have to rely on is basically civil processes, so like sending folks to collections, which I guess can be. So that's it. Yeah. I mean, does anyone have any questions?
With all the pluses on the civil side, why aren't we using that more frequently?
Yeah, and we're working on exploring that. Service kind of requires a penalty schedule to be produced for each rule that you need to use it for, so that's why it's only been implemented for the class for commercial licenses.
I'm sorry.
The civil resource violation system, where it's like a ticket and you avoid the landlord.
Do we have the schedule?
There's a schedule for basically just CMLs, commercial marine licenses. So if you're late or you file it wrong, it's $15. You don't pay within 2 weeks. It's $30. On the DLNR, like, where the DLNR has a finding, like that might. There's some concerns about overloading the board. If they have to hear every single violation that is given out, and board hearings already last all day. We'll schedule it pretty soon. So
What if you use the civil resource violations?
right, and that's only the penalty schedule requirement.
Yeah.
So we have to go through rulemaking.
So it would be the rulemaking.
Yeah.
So on the civil side, can they just pay off the tickets because they have to come to a hearing and do the whole process still in court?
So just for the civil, or
Yes.
I mean, they could be found in violation in absentia. Like most of the time, folks want to show up to state their case or at least raise a bill.
But like I'm going to use an example that I've it's a lot of that the cost has been updated, but if you get like a parking confirmation at a state program, you have to go to court. You can't just pay.
Right. Well, is that a criminal? We're talking about criminal.
No, I don't believe it was criminal. I believe it was civil.
Was there
Civil violation we were required to show up in court? So I'm just wondering about the time frame due to the court system. Is there a ticket process where they can be written a ticket and then just pay it rather than going through the whole process?
Yes, that's pretty much what service is designed for. Small little violations where so that folks can easily pay off if they go still
So that does exist. Where would that fit in this process?
It's a civil resource violation system.
Okay. But the penalty schedules hasn't gone through rulemaking. Is that what you're saying?
They have to go through rulemaking for each regulation that you want to enforce using service. That regulation is so and rulemaking can take a long time. And we're still trying to develop schedules for provisions other than CMLs and conservation lines. I think
What about rules that have penalty schedules built into them already, like the Honolulu rule that has penalty schedules?
I'm not sure if Honolulu uses service right now, but that's interesting. I haven't really.
Because some of the protected area rules have penalty schedules built in. So, is that sufficient, or is there a separate rulemaking process?
I'll have to look at the statute. I would think that you have to indicate that schedules for service, but I don't look at it.
Okay. You've got a question, just use the mic because we're trying to videotape, and if you don't mind using the mic, because I don't think the video might not pick up the sound. Thanks.
Hi, John Seabart, Cosmopolitan Makai Watch. I have a number of questions. Actually, the standard proof in civil is lower, right? I mean, it's a different standard, so that would be easier to enforce and possibly, I'm thinking, to involve Makai Watch people in being able to be some sort of expert witness and get things moving that way. Is that being considered at all?
Yeah, I mean, it's something that we've been working on talking about, trying to see how we can set it.
Well, the thing is, I mean, I don't know what everybody else's experience is, but at Kaanapali, at Kaikili, the FMA there, it's been 3 years since that was formed, and the Makai Watch there has been in effect for a little less than that time, but basically the same time frame. And we have had not a very good experience with a response from DOCARE. And I understand that they're severely overtasked, and that's part of the problem. But the Makai Watch is a really valuable resource, especially in identifying or detecting, as you said, these problems. And it just seems that we could be utilized to a higher degree, even if you can't afford to hire enough officers. But before I get the microphone up, I wanted to say, I know for a fact that Maui County Prosecutor's Office is probably as overwhelmed as the DLNR is. And so my question is there such a thing as attorneys doing pro bono work for the prosecutor's office, especially if they could become experts in this field?
That's actually something that I think we were thinking about a few years back. I know that there are private firms that commit their associates to do pro bono time at the prosecutors for stuff like domestic violence, like temporary restraining orders and so forth. So that's an interesting idea.
Well, because I know a former Maui prosecutor, and basically my impression is they wouldn't ever think about prosecuting one of these cases because they know nothing about it. And so the system is maybe in place, but I don't think anybody really thinks it's working very well. So if we can improve it by doing some of these things, I think that would be good. And some of them seem like they're small things.
Drew, we lived along with the GAY map. On the chart you showed where it shows the flow from the community and the NGO, various other organizations reporting and going up through the dispatch and so forth, I know that it's important from the community that they feel feel useful that their information is being used. I'm wondering if there's anything or any plan to incorporate a feedback of that information back to the community group, rather than just so once it's called in, it's basically lost. But getting that information back to the group that either started it or initiated it, is there anything in the works for that?
I'm probably not the one to ask. Probably not the one that has the most information on that. At least, I mean, yeah, you definitely want to think about, when deterrence is the public's perception of whether the risks outweigh the benefits of non-compliance. So, getting that word out, like there are potential penalties, that they can be, this much. There are instances where rules are enforced. That I think that would, help enhance that function of law enforcement, which is, something that with the board being a lot more transparent of the process might, help to enhance that. I'm not sure about things going on within DoCare too.
Yeah, just so like according to that diagram, if there could be some arrows going back towards the Makai watching the public, that would be good. That's all. And then the other thing I had really quick is you mentioned about the civil information online available. Yeah, that's more transparent. So is there a location that's easy that we can look to see on our own account if there's things happening regarding incidents that have been reported?
If anything goes before the board, whether it's a permit application or a rule change or a violation that's being processed separately, and it's posted online. Okay. That's what I meant.
Is that through the DLNR site?
Yeah.
Okay.
Through the board website. Unfortunately, it's not the process we use normally or regularly, so.
Okay. Yeah. Thank you.
Okay, thanks. So just to follow up, Drew, one thing that came up yesterday in our forum discussion after we were finished, Randy was talking about the Fisheries Enforcement Unit program that they're setting up in partnership with Conservation International and CASA Foundation and the state. And one component of that program is going to be a Makai Watch coordinator. It's going to be based on Maui, but hopefully that'll help with the two-way communication between DoCare and the communities.